Thank you.
Nice.
Thank you. All right, so we're live. We're live. It's live and in living color. This is a special episode of Live, Not Legal Advice, and JR.
The economy. Well
What
paid
happened?
ticks. But,
What happened?
So, William, who we love,
just because it's made money.
I hear him, by the way.
Yeah, well, I just put a comment out that we were going live.
Okay.
So William, they got to talking about it, the Alpine FINRA decision, what you had posted, and there was a little confusion. So I chimed in.
Before you jump into this, come on, let's hold on. Not legal advice. We're just two guys talking. And the question before we start, I wanted to ask JR is if you don't pay your exorcist, can you be repossessed?
I believe so.
Okay. All right. Now go for it.
Wait, you're old enough to have actually been alive and in the theater and understood the original movie, right? The Exorcist.
It was my time during my time. Yeah,
yeah,
I was. I think when it came out, I was 48 years old at the time it came out.
So at any rate, William. Well, first off, William, Richard and I did not go live to shut you up like you thought.
I think actually, even though I said that wasn't the real reason, I think that was really JR's reason, just between you and I. That's all.
William's just such a nice guy, though.
He's a great guy.
He's even better in person. Like you really. So at any rate, they were talking about the Alpine decision, and I chimed in, and then I had to do something else. And when I came back, I heard them talking about it, and they had it all wrong. So obviously I texted you and said, hey, we should go live before this gets too crazy. So Richard, you tweeted out that the appeals court, the full DC appeals court, had denied FINRA's motion for a hearing on the injunction. So why don't you explain what that means? Because the original injunction was in front of a 3-judge panel, and FINRA appealed to the what we call the en banc court, the entire full appellate court. Correct. In DC. So take it away.
I kind of like, because I've been asked in the past, because sometimes people that don't follow this as closely join in, and if we start from today, it makes no sense. So again, Alpine was the broker involved with regard to GTII and purportedly a lot of naked shorting. That particular entity had been disciplined or otherwise penalized by FINRA and the SEC on at least 40 different occasions between 1984 and 2022 for various misconduct. In 2022, for new misconduct, they had a cease and desist order that was imposed against them for, amongst other reasons, for ripping off clients. That was April of 2022. During that year, they filed a lawsuit against FINRA challenging the constitutionality of FINRA.
Right. Now let's take a pause. Yes. That was the lawsuit they filed in Tampa, correct?
Correct. So they filed it. It's kind of sat. Not much was going on. Sometime around April of 2023, FINRA, claiming to have just discovered that Alpine had violated the cease and desist order of April 2022 by committing some 35,000 separate violations, then decided to take expedited action to expel Alpine and basically have them cease business.
And that was the May enforcement action that was taken against them. So that brings us up to May. We're still in Tampa with this argument that Alpine is making that FINRA is unconstitutional.
Correct. And in or about, so it starts. So they have a couple days of those hearings. Mid-hearing, Alpine's counsel decides, why not? Let's try to get an injunction in federal court to stop FINRA from continuing this hearing where they're going to boot us.
Right.
That was the precise language in their brief, by the way.
Yeah.
And So they tried in in Florida. It was unsuccessful. They got booted to DC. Somehow it made its way.
Well, hold on. It wasn't that it was unsuccessful. The day after the hearing on the injunction, the judge said, nope, you're going up to DC with this.
Yeah. So, and for whatever reason, it got kicked up to DC. In DC, they didn't fare well before the trial court. It went up to the appellate court. And in the appellate court, what Alpine was seeking was an injunction to stop FINRA from being able to conduct their the hearing to expel Alpine.
Right.
An appellate panel, 3 judges, granted the injunction. Not only did they grant the injunction, but they talked about the merits of this entire dispute. And that's the merit of that underlying complaint that Alpine filed against FINRA in or about October of 2022. So it basically had stayed dormant, but in this hearing about the injunction before this appellate panel, the court weighed in on the merits of the underlying dispute.
And why did they do that, Richard? There's a reason they do that. Why?
Well, they're leading out to, because one of the qualifications for getting an injunction, so this is what is occurring now. There's going to be briefing about an injunction, but one of the grounds that's required for granting an injunction is that the court has to determine that the party seeking the injunction is more likely than not to prevail on the merits, the merits of the underlying claim.
Yep.
And the merits of the underlying claim is that FINRA doesn't have the constitutional position to conduct the activities they are now.
Right.
So it's a big, if you look at it in the big picture, it's a big issue.
It is a big issue. I don't think people realize how big of an issue it's now become. Hence why Politico picked up on what we've been saying for how many weeks now?
Yeah. So bring it up today's speed. So that injunction, FINRA then went to the entire appellate court and said, this 3-judge panel granted the injunction, but we want the entire appellate court to consider this and rule on it. What came out today was that entire appellate court said, no, we're not going to rule on that. The injunction's going to stand for now. The appellate briefing, which is going to start within the next week or two, literally, because there's a schedule, will start. And the court's going to weigh in not on just the injunction, but on the merits of the underlying constitutionality of FINRA's actions. And what's right. And if depending on the outcome, I'm sure somebody will appeal. Either way.
Let's take a step back. Let's take a step back. So we know the entire DC court refused to hear the FINRA's argument that the injunction shouldn't stand. Can they now appeal to the U.S. Supreme Court on that ruling?
They probably could, but it'll be refused.
You think?
Yeah. Okay. Yeah. I don't think it's not something I don't think. I'm not a constitutional lawyer, but my impression is that's not something they would consider because it may not ever get to them. And they don't want to decide things that they don't have to decide.
Right.
But I think there will be this kind of a discussion of the underlying claims, which is constitutionality of FINRA operating as they do, which obviously is a huge issue, and why I'm a proponent. And I know this wasn't the point of this, but why I'm such a proponent of FINRA acting separate and apart from this case is because I don't know how long it's going to take, and the outcome may not be in FINRA's favor. And they could still, in essence, what the issue here is that they can either take the position that they have the right to conduct these in an administrative body, or they can go and use the federal courts. Right. And they're kind of being resistant to using the federal courts as of this point.
Well, do you think that, or what are your thoughts, or let's have a conversation about this, that, now that the full DC appellate court has refused to hear the argument on the injunction, we know that the Jaworski case is going in front of the Supreme Court at the beginning of the term in October. Do you think that FINRA could say, all right, in order to save a little bit of face on this so that a DC district judge doesn't rule the wrong way, since the similar issues are going in front of the Supreme Court, do you think FINRA would go to the district judge and say, look, we're going to file for a stay on all of this pending the outcome of the case that's in front of the Supreme Court right now?
It's an option kind of where they don't lose anything other than time. But that gets, that's why I go back to that point. They're arguing, big legal issues, but as to the shareholders that are impacted, that time is precious.
Well, and I guess from a legal strategy standpoint, though, if I'm FINRA, that DC district court is going to rule. We know they would likely rule before the Supreme Court would rule on Jaworski. If they're concerned that the district court is going to rule in their favor, they could potentially have now a district court case that outlines the constitution or lack of constitutionality that opposing counsel in Jaworski could use against them.
Yeah, and I see there's a question about what happens if Alpine wins, because there might be like an intermediate stage. They might win, and then it might go on appeal, and there may not be like a decision on the appeal, right. And they may have a chance to either withdraw something or take other action. So if Alpine wins, that just means that FINRA loses power and authority. That's right. What ultimately it does. I don't think it helps retail shareholders unless there's something that fills that gap. And again, there may be a time where when FINRA, let's say they lose, they feel at risk, but something's on appeal. And maybe during that time period, they get really aggressive protecting rights. So they'll have that position to argue when they're, from a practical standpoint, when they're arguing before the U.S. Supreme Court. But we really don't know what the outcome will be, other than the fact it's a potentially huge outcome from a bunch of scumbags. That's what the part is, the kind of the flip side of this. None of this excuses Alpine of anything, right? So of their misconduct,
right?
So to the extent that we get some benefit, retail shareholders get some benefit, it doesn't change that they're scumbags, and eventually, I think we all believe that they're going to be kicked out. It's just a matter of what the timing is.
And if you take a step back and say, well, Alpine wins, at some point, FINRA is still going to do something. They're going to try to stop them from doing what they're doing. For all we know, FINRA could put their hands up in the air and say, we're turning all this over to the Department of Justice. And then the Department of Justice comes after them. I mean, everybody needs to remember the case is not about Alpine's guilt or innocence. They're guilty. They've now had 2 adjudicators say they're guilty. The case right now that seems to be moving in their favor is about the constitutionality of FINRA and their adjudicators.
Yeah. So in that case, if FINRA didn't do anything different, and again, this is in FINRA's court, really, because they could work around this issue.
Right.
But at this point in time, it's just to the constitutionality of FINRA, and through Alpine's arguments here, and theoretically, if you follow this all the way out, if this court, and if it was followed, if this is how they rule and this is followed, if they say FINRA didn't have the authority to act, then and we've talked about this, it puts all of FINRA's decisions in question, because they're going to have acted pretty much the same way in all their cases that they're handling. If they don't,
I don't think it puts all their enforcement. It puts their enforcement actions in questions that occurred in front of one of their adjudicators. you know, all those fines that are out there that listed that these organizations agreed to pay, and all the what, I forget what's the term they use, you know, guilty, but no, we're admitting to the charges, but we're not admitting to the guilt.
Like a no contest plea.
Yeah, like a no contest. So it doesn't put in question those. It puts in questions all the decisions the enforcement adjudicator made. So anyone that disagreed with the enforcement action and went in front of one of their adjudicators, that's what it brings into question.
I don't know if that's true, because I think at some point in time, the judge has to sign off on that deal. Even if it's just a rubber stamp, it's got to be signed by the judge.
Well,
so and if that judge is not properly appointed, does not have proper authority, then I don't think that's a Now, I'm going to say something beyond that. So I want to draw a distinction here. I think if they win, what they get is a do-over. That's all they do. It doesn't change that their misconduct's not going to be interpreted as misconduct, but they get a do-over. That's why I think.
Well, but do they? I mean, again, if you take the broader view of the constitutionality and what it means, see, I tend to think this is more of a laser-focused issue based on the Jaworski case, that's really looking at, are these adjudicators Article 3 judges such that they have to be provided, such that the defendant in the case has to be provided due process?
So this is how I see it. I'm the attorney for Alpine, and this is not, again, we're not experts in this area. So whatever we are saying here if it's accurate, it's been considered already. It's not, we're not giving these new earth-shattering theories. But if I'm the attorney for Alpine, what I'm saying is, listen, the reason why we're here in the first place is because you conducted a hearing in April of 2022 under the same system, using the same defective judicial system, and that ruling's got to be tossed out. That's my argument, because it's basically, you know, it's in law school when we go through criminal law, even if we do nothing, we've heard of basically the fruit of the poisonous tree, right?
Well,
Everybody's heard that. So it's kind of like, if the system is deficient, then it's rotten as far back as you want to go.
Right, but all I'm saying is the only piece of it's that. So you're saying the apple's rotten, therefore the whole tree is rotten. I'm just saying the apple is rotten in terms of the adjudicator, but the enforcement part of it is still constitutional. So FINRA's not losing their enforcement authority. They're losing they're losing their authority to adjudicate the enforcement actions.
Yeah, so I think they have to figure out. I think they have to figure out
enforcement, but they don't have the person now that's capable of adjudicating that enforcement.
Yeah, they have to figure out a different way of appointing judges, for example. Right. It's got to be different. But what I'm saying is, I am saying that's all well and good. You know, that is. And, you know, everybody's excitement about FINRA getting knocked around, that's all well and good, but does us no good unless we get FINRA, because I don't know how it's going to turn out. JR doesn't know how to turn out. We don't know how long it's going to turn out. But I do know, because it's the facts are the facts. So if I went in, even though the ruling might get tossed out, so we have some kind of decision, even if it gets tossed out, there are facts and documents that exist that will establish certain facts and documents. So I could take that stuff today into a federal court today and get a remedy against Alpine that would not deal with the discipline, because that's what this stuff is dealing with, is the discipline of Alpine and getting them out of business, but deal with the misconduct itself. And if you deal with the misconduct, that's it. We're done.
Well, I still think they can deal with the discipline in federal court too. That's what I'm getting at. But let's take a step back and talk about why FINRA has these adjudicators to begin with. And it's because most federal agencies that have some type of enforcement authority have these adjudicators that are specialized in the rules and regulations that that agency promulgates in order to expedite things. because if FINRA takes this thing in district court, they're not getting expedited. They're going to be case number 210 in the month of October. And when we get to case 210 is when we get to that case.
Well, not only
that,
they lose control over the adjudicator.
That's right. They lose control over the adjudicator as well, too. But that's why these agencies and SROs have their own adjudicatory arm, is to expedite things. So
to expedite, I think, and to control the outcomes. If they want something to go in a particular manner, they have more control over the rules and the process than you would in the federal court. I mean, just the difference is due process is interpreted differently under an Arbitration Procedures Act versus the Constitution of the United States.
Right. So but let's be realistic. Do we want the full rules of the federal court in front? And I mean, they're criminals. We know they're criminals. They violated the law. They cheated their customers. They didn't pay the appropriate fees to DTCC. They're criminals. Does that mean that they should be opened up to the full realm of due process instead of an expedited adjudicator that is knowledgeable on the rules and regulations that are being enforced against them?
Well, think about it this way: if that were the case, or was the case, depending what English language I could speak, it's much more likely that they would be deemed a state actor. That whatever they were doing would be an action on behalf of the state, and much greater chance that they would be then obligated to be consistent with the Constitution. And if we were, for example, somebody in arbitration with Fidelity over MMTLP, I would get a much better shot before that tribunal because the rules would be more favorable to the consumer.
But I think, let's not get into that, because then we're talking about specific strategy as it relates to your case. We could talk about that offline. These two communities are in a catch-22. You have the GTII community that wants this thing done, wants Alpine kicked out, and blah, 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 blah. But if you look at it from the perspective of the MMTLP community, finding FINRA a state actor is extremely beneficial to what's going on in the MMTLP case. But I also think it's beneficial to the overall, all of these communities, because now it opens up FINRA to the full breadth of the Constitution. And I think it opens them up to FOIA requests.
But that's true. But the point I always want people to remember is that getting rid of somebody is good, but you got to replace them with something better, because the whole is not good for any reason.
And let's go back to something we talked about the other night. FINRA obviously doesn't like what's happening. I'm sure they're not happy that the full court in DC did not want to hear their case and shot them down. FINRA knows how to fix this. They would just need an act of Congress to pass a piece of legislation that puts forth the requirements for adjudicators in this instance. Because if you go back and read the appellate court decision in Jaworski, the court outlined what's missing and why they didn't feel as though these adjudicators had the proper authority. So this is a fix that Congress can do, but FINRA's got to go to them and say, this is what needs to be done. So this could go either way. We should be on the lookout for legislation that is sponsored by someone to correct this issue that FINRA's found themselves in.
So quick summary. So the appeal relates to a technical issue involving FINRA's right to proceed against Alpine. But the decision on that technical issue might relate to FINRA's constitutional ability to go forward. That's kind of the summary. And that's what the appeal is related to. Has nothing to do with Alpine being scumbags, by the way.
No.
And related to that, when the cannibals showed up late to the buffet, they gave them the cold shoulder. Last but not least, even though we weren't going to talk about it, but since we did talk about this briefly earlier, That covers the point you wanted to address, by the way.
Yeah. Well, and again, it was to clear up the confusion. William was confused. I confused him. So that's kind of why you and I decided to do this quick like.
And I believe, by the way, I think it's confusing procedurally because you got all kinds of things going on within things.
Yeah. And I was just trying to clean up a misstatement. And, you can't type fast enough. And these comments are continuing to scroll. And so, it was just my fault. So,
yeah, it makes, at some point in time, it loses context. It doesn't make sense. Yeah. Exactly. So the other thing I'm going to briefly touch on, and I'm going to talk about it maybe in a video, but I thought I was interesting to see yesterday, and we hadn't decided we were going to talk about it, but let's do it for 5 minutes. Bill St. Louis is the new head of enforcement of FINRA. So St. Louis, I love the name, by the way. Bill St. Louis.
Great city.
Even though I think FINRA are a bunch of scumbags and I hate them, Bill St. Louis, I like your name, just to be between you and I. So Mr. St. Louis, or Missouri, as his friends like to call him, he took over for an interim person who took over for Ms. Hopper, who resigned or left or retired or whatever in or about January, I think, of 2023. And she was the head of enforcement. So ironically or coincidentally, whatever the proper term might be, she was there during the period of time of MMTLP. And when I was reading yesterday about the movement to the current enforcement person, what struck me was the discussion about the contact between the head of enforcement and Mr. Cook, the CEO of the company. And it was clear that there was a lot of discussion between head of enforcement and Mr. Cook, which leads me to believe that Mr. Cook was advised at all times of everything meaningful that was going on with MMTLP. And I think, and I'm, again, do I know that firsthand? No, I'm just surmising. But if that's the case also, then he was the actual decision maker. It's not like he was in the dark. If he knew what was going on, he had veto power. He's the head of the company. Then he made some elections or let things occur. And again, I'm speculating, but I found that interesting, that line. And then on top of that, and then I'm going to finish this, and then you can say whatever you want. So I found it interesting. Hooper leaves under somewhat cloudy circumstances, never really been explained, and maybe it's innocuous. Maybe there's nothing there. But she left. Then an interim person was placed in there, and then Mr. St. Louis is now the permanent guy. Mr. St. Louis has been there for quite some time. Interim person was there for quite some time. So I thought it was interesting that interim person was not the one who was named the new head of enforcement, because I would think that would be the type of person that would succeed the current one, unless you were going outside of the company, if you were bringing somebody new. So anyway, I don't know if it means anything, just struck me as interesting. May not be interesting. Now you can give me your take here.
Well, I think, Mike, I would go a little further. I would be shocked if the head of FINRA did not know what was going on, and only because we know that the chief legal officer in FINRA knew what was going on, because he was quoted in the New York Times article that was written, let me take a step back. One of the major news outlet articles, he was quoted, and I believe the quote was, if we hadn't have halted it, investors would have been screaming their heads off. Now, I always thought that quote was a little bit ambiguous, because he didn't say which investors would be screaming their heads off had they not halted it. So, and when lawyers talk, and you guys know this from listening to us, we choose our words very carefully, especially if we're going to be quoted or have those words appear in written format. So if the chief legal officer in the organization knew what was going on, it's a sure bet that the CEO of the organization also knew what was going on.
And, we were surmising that in the past, but what I read yesterday in terms of the appointment of Mr. St. Louis confirmed that. And let's just take it one step farther. So all those communications, the ones we're referring to that are referred to in the FOIA documents, that's kind of the source of some of that information. So
right.
Anything that's referred to in the FOIA documents would have made its way up, at least the way we see it.
Right.
It's been now confirmed it would make its way up if it was material to the top.
Right.
And since it was communication between FINRA and the SEC, then we have to assume it wasn't just Mr. Cook who was aware of this at all times or all meaningful times, but
right.
It's got to be Gensler on the other side, who had the same relationship, I'm sure, with his top legal person. When there's
right.
a problem, they would rely upon top legal person to tell them to take care of it. But me, CEO, says, go take care of it. That's kind of the way it goes.
Well,
and so I would surmise that beyond just us thinking that they knew, they did know.
Legal officers, and I know this from working in a large corporation and working with the legal department, legal officers don't make decisions in a vacuum. They don't. They never do. And there's a reason why they don't do that. They take direction no matter what level you are, whether you're the assistant general counsel that's all the way at the bottom, or if you're the chief legal officer in the organization. They are not making decisions in a vacuum. They are taking direction.
I disagree. The reason why they're not making decisions in a vacuum is because they can't breathe in a vacuum.
You know what I meant. You know what I'm getting at.
I do.
The legal department did not make the decision to halt it. The legal department merely indicated and explained what the law is and what FINRA's options are. Someone outside of the legal department made that decision, and I think it's a sure bet that it came from the highest levels of authority at FINRA.
Yeah, it's got to be at a senior executive level.
Exactly.
And again, they have now, when they appointed Mr. St. Louis, besides the fact it's curious to me that the interim person was not hired, but when they hired Mr. St. Louis, they've disclosed that's kind of their structure. Right. And, as I mentioned, I'm in the arbitration and I'm going against, it's interesting to me because I have FINRA, I'm in a FINRA arbitration, but I want a lot of FINRA people as witnesses. And it's supposed to be under FINRA rules. And I'm interested to see how they respond to that. But one of the people I obviously want to speak to now is Mr. St. Louis.
Sure.
Who was, I think he's the head of the tech crime detection something prior to this. So I would think he would know. But anyway, this has gone a little far afield of what we were.
And I only had a few minutes, Richard. I have to get back to work.
So your 33 minutes are a few. So anyway, so hopefully we've clarified that. If it is not clear, then just blame JR.
Yeah.
And, don't ask me again. Anyway, have a great day, everybody. Be well. Take care.
Absolutely.
Talk to you later.
Yep. Bye now.